Okay, now we are live and welcome this morning to our public hearing of, we have a set of public hearings this morning for the Health Coverage Insurance and Financial Services Committee. And we'll start with committee introductions as is typical. So I will start with Representative Matheson.
Good morning, Madam Speaker. Nice to see you all. My name is Christy Matheson. I represent District 1, Kittery.
Representative Arford.
Good morning, Madam Chair. I represent District 49, which is the western part of Brunswick.
And Representative Evans, are you with us?
Thank you, Madam Chair. I'm Richard Evans. I represent House District 120, including the towns of Atkinson, Brownville, Dover, Foxcroft, Medford, Milo, Warnerville Township, and Lakeview Plantation.
Excellent, thank you. Representative Quint, you're just in time, go ahead.
Hello, my name is Tracy Quint. I represent House District 144, which is the Greater Holton area, and it's nice to see you all again this year.
Nice to see you as well. And looks like you're not in Augusta and at home this year, which is wonderful. It must mean that we've got some better internet up your way.
No, I'm actually at someone else's house and the internet may be sketchy and I might be kicked off, but I had to come home for something else. And so I'll be down in Augusta this year as well, but thank you.
Okay. All right. Well, hopefully we'll be able to find some broadband to get up your way with all of the efforts that we've made in that regard. It's going to take some time, I know, to build it out. Representative Melorano.
Good morning, I'm Gina Melorano. I represent House District 62, which is part of Auburn.
Representative Brooks.
Good morning, my name is Heidi Brooks. I represent House District 61, which is part of Thornton.
Representative Morris.
Good morning. I am Representative Joshua Morris. I represent House District 75, which is Turner, Leeds, and part of Livermore.
Senator Brenner.
Thank you. Good morning. My name is Stacy Brenner. I represent Senate District 30, which is all of Gorham, part of Scarborough, and part of Buxton.
And Representative Tepler.
Good morning. My name is Denise Tepler. I represent House District number 54, which is all of the town of Topsail.
Great. And I'm Heather Sanborn. I represent Senate District 28, which is half of Portland and half of Westbrook. And we are helped out today by our committee clerk, Edna Caford, and as always, by Colleen McCarthy-Reed, our analyst from OPLA. And as I mentioned, we do have 3 public hearings today, and we're going to take them in order today, starting with LD 1752, followed by 1815, and then 1836. The second 2 bills I have sponsored, so my House Chair, Representative Tepler, will be chairing for us for those 2 hearings this morning. But we will start with LD 1752. I'm going to bring the sponsor over, and then I'm going to let Representative Bleier introduce himself. Let me just bring the sponsor over. And while Senator Bailey is headed over our direction, Representative Bleier, please go ahead.
Thank you, Madam Chair. My name is Representative Mark Bleier. I represent District 22, which is Leamington and part of Buxton, Standish, and Leamington.
Welcome. And Senator Bailey, welcome this morning. And please go ahead.
Thank you, Madam Chair. And good morning, Senator Sanborn and Representative Tepler, and esteemed members of the Joint Standing Committee on Health Coverage, Insurance, and Financial Services. I am Donna Bailey. I represent Senate District 31, which are the towns of Hollis, Leamington, Old Orchard Beach, Saco, and part of Buxton. Today, I'm pleased to introduce my bill LD 1752, an act to provide insurance coverage for a beneficiary on a transfer on death deed. I got the idea for this bill from the court case of Don Strott Robinson versus State Farm Fire and Casualty. In that case, Dawn, the plaintiff, was the beneficiary of a transfer on death deed and the sole owner of the property in question when it burned down in a fire. The fire occurred just a few days after Dawn's uncle passed away. However, because the property insurance issued by State Farm was a personal contract between Dawn's deceased uncle and did not run with the property after it passed to Dawn, State Farm denied Dawn's claim for loss of the house and loss of the fair rental value of the house under her uncle's policy, and the court upheld that decision. When I heard the story, I contacted the Bureau of Insurance to see if beneficiaries of transfer on death deeds have the same risk in Maine. For those of you who don't know, Maine recognized and has allowed transfer on death deeds since 2019 when we updated our probate code. It turns out that they do run that same risk, and that's why I brought forth LD 1752 before this committee. This bill would allow someone who is a beneficiary on a transfer on death deed to be added to their homeowner's insurance policy. It also gives beneficiaries a 30-day grace period to set up their own homeowner's insurance after the death of the grantor, because who's able to quickly take out a new insurance policy while they're still grieving the loss of their family member or their loved one. In the case I discussed earlier, the home was set on fire by the grantor's ex-wife, which compounded Dawn's loss. In addition to cases like that, I'm hoping that adding an insurance beneficiary will protect homes transferring under transfer on death deeds from other accidental damage caused by human error, mischief, as well as natural disasters. I am happy to answer any questions committee members may have.
Thank you, Senator Bailey. Are there questions for Senator Bailey regarding this bill? I have one. Senator Bailey, I know you've been involved in the reforms to the probate code a little bit, or would be more familiar with this than some of us might be. Can you help us understand what a transfer on death deed is and why someone might use it?
Sure. A transfer on death deed is just what the title implies. It's a deed that someone signs now, and it gets recorded in the registry of deeds just like any other deed, but it doesn't take effect until the person dies. So, for example, if I wanted to transfer my house to my son, I could sign a transfer on death deed now and convey the property to my son, record it in the registry, but the title to the property doesn't actually pass to my son until I die, and then it passes automatically. So it saves someone from having to go through probate. The deed is also revocable during my lifetime. So if I changed my mind and didn't want my house to go to my son, I could revoke the deed even after it was recorded. It's really meant to be a simpler and less expensive and less complicated from a legal sense way to transfer title to property without having to set up a formal trust, for example.
And if you didn't have a transfer on death deed, so prior to 2019 in Maine, for example, if you wanted to, I guess in this case it was an uncle, if you wanted to pass your property to your niece, I assume you would have done that in a will, is that right?
You could have done it in a will, or you could have set up a trust where the niece was the beneficiary of the trust. And so you'd transfer title to the trust and then the property would pass that way. Or the other option in Maine prior to 2019 was you would actually need to add that person onto your title currently, add them, for example, as a joint tenant onto your title.
And so at the moment somebody would die under any of those other circumstances, would their homeowner's coverage continue for the property?
Yes,
Okay, so this is the situation where, because we've added this new option that was supposed to simplify things, it also means that your homeowners could terminate at the very moment that you die.
correct.
Okay. Thanks for helping us understand exactly what the problem is, and for bringing the bill forward. Are there any other questions for Senator Bailey? Okay, seeing none, thank you for your testimony. And next, I will ask if there's anyone else in the panel who wishes to testify in favor of the bill. Please raise your electronic hand at this time. Seeing none, I am going to turn to those who wish to testify in opposition to the bill. And I'm going to welcome back our former colleague, Robert Foley. Good morning. Bob, can you hear us? We can't see you or hear you quite yet. If you can unmute yourself and activate your video, we should be able to hear from you.
There I am.
There you are. All right, we can hear you now. We can't see you still, but that's fine if you don't have that ability. There you are. Wonderful. Nice to see you.
Good to
Good
see
morning.
you folks as well. Senator Sanborn, Representative Tepler, distinguished members of the Health Coverage Insurance and Financial Services Committee. My name is Robert Foley, and I've been a licensed insurance professional here in Maine for the past 45 years. I hold the professional distinction of Certified Insurance Counselor and had the privilege of serving on this committee for the prior 6 years while serving in both the House and the Senate. First, I want to thank Senator Bailey for her support in the past when I brought the initial legislation forward to create the Transfer Upon Death Deeds Act. Her good work within the Judiciary Committee helped ensure that this provision of law was included in the rewrite of the probate code, which she masterfully handled. It is a good and important provision that was added to the statute. I am unfortunately testifying this morning in opposition to LD 1752, as I believe it may be unnecessary and potentially more problematic than what the bill attempts to accomplish. One of my concerns for LD 1752 as proposed is the 30-day coverage extension period. The current language within the personal property insurance contract provides for a specific continuation of coverage upon the death of a named insured. This provision extends coverage to any person having legal temporary custody of the property upon death of the insured and/or any person or member of the household while a resident of that household. It has been my experience that most companies are willing to work with the agent and our clients through the process of an orderly transfer of the property, depending upon multiple underwriting circumstances. I do not believe that it is necessary of this provision of the bill requiring the 30-day coverage extension after the death of the insured. In fact, if this provision became law, I'm concerned that the insurance companies would in fact cancel after the 30-day, regardless of the circumstances. That would create a rewriting of the policy and most likely a much higher rated surplus lines policy. I understand that a recent court case may make this issue problematic, but there are other ways to protect a designated owner on a transfer upon death deed without this bill, which I'll discuss later. Additionally, adding an individual to the policy as a named insured who has no insurable interest in the property creates a potential underwriting issue for the insurance carrier, as the liability provision of the policy extends worldwide to any named insured on the policy. Insurance carriers will be reluctant to extend liability coverage to an individual who is not a resident member of the household, expanding their potential exposure beyond the risk they were underwriting for. If the insurance company were forced to add a new individual as a named insured, they could re-underwrite the policy and reclassify the premium based on a potential new risk assessment, not necessarily to the benefit of the original policy holder. Lastly, this bill creates a potential problem when attempting to settle a claim, as the policy requires that payment be made to any named insured and any other interested parties listed on the policy that has a financial interest in the property, such as a mortgagee. There are many scenarios that I can imagine that makes this situation problematic for adding someone as a named insured who has no financial interest in the property at the time of the loss. Naming an individual as a named insured who has no financial interest in the property gives them financial interest in the policy, and that interest could be detrimental to the property owner. If the property owner is wanting to provide some evidence of insurance and protection to a designated beneficiary upon death of the insured, they can already be listed on the policy as an additional interested party, similar to a mortgagee. Under that listing, the only interest that party has is whatever their financial interest is at the time of any loss. It does not extend liability and does not provide any payment on a claim, as they have no financial interest until the death of their named insured. The property owner can already add the designated beneficiary to a policy as an additional interested party without this legislation. While I appreciate Senator Bailey's concerns, I believe the potential problems with this proposal outweigh the benefits this bill attempts to address. Based upon these concerns and the reality that any person who has been named as a designated beneficiary on a transfer upon death deed can already have the protection they need without being designated as a named insured, and creating many unforeseen problems. And I urge the committee to vote ought not to pass on this proposal. Happy to answer any questions.
Thank you, Mr. Foley. Are there questions, Representative Tepler?
Thank you, Madam Chair, and thank you very much for being here, Honorable Mr. Foley. It's nice to see you again. I guess I remain confused about how a person who inherits a home, who is not living in that home, can have appropriate insurance for the home unless there's been pre-planning that that inheritee is on the policy. So I guess that is the circumstance. I still don't understand how we're protecting someone. So if I die and my daughter, who doesn't live with me because she's an adult and has her own family, inherits the home, how does she protect the home with insurance until she's able to sell it?
Well, again, the current language in the contract already gives provisions for the death of the insured. And it extends to any legal representative of the deceased. So if the niece or daughter or whoever becomes the legal representative of the estate, the policy provides coverage for that individual during the transfer, and or any legal representative that may be appointed by the court also is protected. So there are provisions within the policy to allow that to happen. However, if in fact we have a person like the situation with somebody who's not in the household, it's a niece or somebody living elsewhere, and we want to provide extended coverage, we can do that through adding them as an additional interested party rather than a named insured. And that's the concern I have, is a named insured has full benefits of the policy, the same as the owner of the policy. And, you know, let's, for instance, let's say the owner of the property is alive, they're the named insured, and they've added somebody who's a transfer upon death recipient. They add them as a named insured, and there's a loss to the property. The insurance company has an obligation to name all named insureds on any settlement and to deal with any named insured in that settlement. So if the named insured agrees to settle with the insurance company, the other named insured, who's the designated beneficiary, could challenge that settlement and request a different settlement amount, and or a check being issued to settle a claim would name both of them on the check. That becomes problematic.
So is there any kind of language, Bob, that could be added to the bill that would make it possible to name an insured who doesn't have an interest in the policy until the death of the original policy owner?
Well, as I said, they can already add them as an additional interested party. They can name them on the policy as an additional interested party, similar to a mortgagee. A mortgagee gets added as an additional interested party, but they don't get underwritten for liability. They have no say in any claim settlement. And that's a much better way to provide that protection. If in fact the insured dies, the interested parties then get whatever interest they have at the time of their death. And that can happen today.
Okay.
I mean, again, the concern I have with that provision of the bill is naming somebody as a named insured, because a named insured has the full benefit of the policy, regardless of whether they have any financial interest or not.
Let me see if I can help untangle this a little bit, because I think we're struggling a little bit with the insurance jargon, and then Representative Blair, I'll get to you in just a moment. Mr. Foley, if we change the language in the bill so that it said an insurer shall include as an additional interested party on a contract of insurance a designated beneficiary, or something like that, we would deem the designated beneficiary of a transfer on death deed to be an additional interested party. Would that work? And I'm setting aside the 30-day cancellation piece because I'm not sure that that's necessary if we're able to cover the gap. But here's my concern. I think if in a circumstance where the house burns down 2 days after the transfer on death deed takes effect, I want to make sure that an additional interested party is actually sufficient coverage for a payout to the person who owns the house at that point. Can you help us understand that piece?
Yeah, I mean, certainly that would be a way of, again, they can already do it, but if we want to make it clearer, adding that to this bill rather than the name insured as an additional interested party, because an additional interested party, they have whatever benefit in the property that they have at the time. So if in fact the person dies and they have ownership of the property, they now have the benefit of the policy. So I think, changing the named insured to additional interested party certainly would satisfy that.
Okay.
And again, that would take away any need for the 30 days because the additional interested party continues on with the benefits of the policy.
I see. Okay, that seems like the way to solve this issue then. That
does take away the concerns of having to re-underwrite or the companies having a concern with adding new people to the policy that they didn't intend to insure.
Okay. Representative Blair, go ahead.
Thank you, Madam Chair. Thank you, Honorable Foley. Glad to see you again. I guess it's more of a clarification, a little bit more. If somebody owns a piece of property and they were to die and they don't have a will or a trust or anything, and it has to go through probate, from my understanding with you, you're saying that the insurance only carries for 30 days after death. What happens if it goes through that legal process? How is the building insured till the end of that process?
Well, currently the policy would extend coverage to the estate or any legal representative appointed by the court. So the policy would continue in force. And we've had many situations where this has happened, and we simply call the insurance company and we change the policy however we need to. And in some cases, we put the policy in the name of the estate of the person. And in most insurance companies are willing to do that. It's really a matter of communication at the time of a death as to what's happening to the property. Insurance companies, if they know that there's somebody living in the household, there's a legal representative in the household, and we can change it to their name, or we can add the estate of. I mean, there are other ways of doing it if we're made known that that's happened. I'm not the case that the good senator represented with the State Farm case. I'm not sure the specific circumstances of that case, although I know it happened in Minnesota, and their transfer upon death deed may be a little different than ours. But regardless of what that is, I think, as Senator Sanborn had mentioned, clarifying this, that they become an additional interested party would certainly make that far more a far better way to do this.
Representative Brooks.
Hello, Honorable Mr. Foley. Good to see you. I had a question about interested party and the definition of interested party. So it seems as though with further clarification that the interested party, if there is one person who may or may not be related, but is named as the beneficiary of an estate, let's say, or a household. And again, I guess using the example of somebody that has more substantial interest, like let's say they have a bedroom in the household from childhood or something like that with some belongings there, for example. So they would be an interested party in my mind from the beginning, but then they are also named as a beneficiary upon the death of the person, and now they're the interested party officially. If something tragic happens, like in the State Farm, Minnesota instance, and the other person had just passed away, would the solution and compromise we're working towards give them the full benefits of the household and everything in it? Is, I guess, a question I had.
It would. I mean, the situation where you talk about somebody having a bedroom, if they are a resident of the household at the time of the death, the policy automatically covers them because they're a covered insured under the policy as a resident of the household. But adding somebody as an additional interested party gives them whatever legal right they have to the property. The insurance company will protect that right, similar to a mortgagee. The mortgagee is named on a policy. If there's a claim and they present that they have a legal interest, financial interest in the property, they will be protected by the policy.
Representative Tepler.
Thank you again, Madam Chair, and thanks again, Mr. Foley. My question sort of builds on Representative Blyer's question. So during the probate process, can the designated beneficiary who is in the will or who is the assumed beneficiary under Maine law be added as an interested party before the probate process is complete?
Yes.
Okay.
They can be added on at any time.
Okay, good to know. Thank you.
I mean, the insurance company would, if we want to add somebody as an additional insured, they would say, why additional interested party? They would say, what is their interest? And then we simply would say they're designated as a transfer upon death deed recipient. That would be the end of it. And sometimes if we add, sometimes you add an individual who may be holding back a mortgage, and that would be the same thing. You'd say this individual is holding a mortgage. And you just let the company know who the individual is and why they're being added.
Mr. Foley, do you think it makes sense for us to have us operate as a matter of law, kind of that someone is deemed an additional interested party if there's a transfer on death deed, in order to ensure that interests are protected if they don't have an insurance broker who's quite as talented as you are?
I think that might be a good question for the Insurance Bureau as to their feelings on how, because again, we're sort of messing with a contract that's already established, but so I guess I would defer to the Insurance Bureau to see how they feel about that, doing it that way.
Okay. All right. Thanks so much. I don't see any other hands raised. So we do love seeing you here back in our committee, and we'll collect our candy and goodies at some future point when you're with us in person.
I hope that's soon.
All right.
Good
Thank
seeing
you.
you all. Thank you very much.
Nice to see you. And next we'll hear from Bruce Garrity. Good morning, Mr. Garrity. Go ahead.
Good morning, Senator. Thank you for the opportunity to speak on this bill. My name is Bruce Garrity. I'm here on behalf of Senator Sanborn and Representative Tepler of the American Association of Property Casualty Insurers. That is the, we go by the acronym APCIA, and that is its members provide the most insurance, majority of the insurance on the property casualty market written in Maine, including some Maine companies, and there are some 1,200 members. Let me, if I might, make a couple of points at the outset. It's black letter law. It's very clear that in order for someone to claim under a policy, they need two things. They need an insurable interest, and they need to be an insured. I couldn't make a claim under Senator Sanborn's homeowner policy because I have no insurable interest in her property, and because I'm not an insured. You need both prongs in order for an insurance policy to cover, and that's crucial because a company has to underwrite basing its decisions on who is the insured as well as what is the property. And as Mr. Foley commented, if you make them an insured, now you're providing essentially worldwide coverage totally outside the scope of what was intended. So that's one of our concerns. The second primary point I'd like to make is that usually a transfer on death deed passes outside of probate rather than being part of a probated estate. The whole idea is regardless of who the beneficiaries might be under a will, or who the representative of the estate might be, the property is already transferred at the time of death, regardless of probate, regardless of whether the estate is intestate. So I think that's another factor that the committee needs to consider. One of the concerns we have in this case, in this legislation, is the last sentence says, the insurer may not cancel the contract for at least 30 days after the death of the transferor. Well, in most instances, the insurance company is going to have no idea someone has passed. That's not, there's no requirement that you immediately send that notice along. And the words in the proposed language are at least. So one could have a situation where the policy coverage goes on indefinitely. And we think if the committee wants to move forward with the legislation, that's something that definitely needs to be addressed. If you make them an insured, you also have the limitations of the Cancellation and Control Act on when you can non-renew and how you can cancel a policy. And I don't think that is addressed in this legislation. One of the other concerns that we have, and I suppose that it's something the committee has to consider if it wants to move forward with the bill, other than in the fashion proposed by Mr. Foley. The language in the bill, starting at line 26, says the designated beneficiary has an insurable interest in the property. That doesn't make that individual an insured. You have to be an insured. You have to meet both prongs of the statute. So I'm not sure the language as it's proposed works, given the concepts behind how a policy is to be written. One of our other concerns is that clearly the intent is to protect the home and perhaps its contents. What this bill would do is apply to any piece of property that is covered under a policy. Clearly, the intent is to address a homeowner issue. It's not intended to address other remote pieces of property, nor in our view should it, because once again, you would be expanding the scope of who is an insured and what is the coverage of the policy, quite frankly, well beyond even a concern with passing of home ownership. So those are several of our direct concerns, Senator. And we do believe under all these circumstances, the bill, at least as drafted, isn't going to work and is going to punch a hole in one of the most primary concepts behind insurance, which is the two-pronged test that I already mentioned. So for those reasons, we are opposed to the bill as drafted, and I appreciate the opportunity to have made these comments.
Hi, Mr. Garrity, nice to see you this morning. I'm wondering if you heard our back and forth with Mr. Foley, and whether if we were to simply change the words named insured to additional interested parties and strike the last sentence of the bill, probably strike the last two sentences of the last sentence. The second to last sentence is correct, I think, but to strike the last sentence of the bill regarding 30 days, whether we've cured the concerns that you raise. I think it's really just not knowing exactly the terminology in insurance,
Right.
Whether named insured and additional interested party are obviously not the same thing. Does additional interested party solve the issue?
I suppose if you put it in the face of the statute, it could. I think it needs to be clearer if you're going to do that. I would urge the committee to look at the case of Fry versus MMG Insurance, which dealt with an analogous situation. A person had a life estate, the person dies. The people who took the property after the life estate were held not to be entitled to coverage when 6 or 8 weeks after the death, the property was destroyed in a fire. That's a 2018 case. I actually think that's perhaps more important than the Minnesota case. I think it's a bit more on point, and obviously it's a main case. So we would urge you to look at that. To answer your question, in addition, Senator, I think you would have to put in a clause that says it's a ground for cancellation after some limited period of time, because right now it wouldn't be a ground of cancellation if you made them an additional insured. And I think it would be appropriate and actually necessary to limit the scope of the situation to the dwelling house and perhaps contents. What's interesting, as an aside, is that in the Fry case, the court ruled there was no coverage, but the insurer paid contents under a different provision of the policy. So I do think that's a valid case for the court to, for the committee to look at here.
Representative Tepler.
Thank you, Madam Chair, and thanks for being here, Mr. Garrity. So given that there appears to be a problem in Maine as well as in the case from Michigan, what would you, as an insurance attorney, suggest as a solution to protect people who inherit a home through a death deed and may be found not to be an interested party, as it were, or an insured under the insurance policy as it currently exists?
Thank you for the question, Representative. To the extent we're talking about an interested party, I think Mr. Foley's comments actually addressed that issue. To the extent that you're going to characterize someone as entitled to coverage, this is the conundrum. If you call them an insured, then you're violating the policy and creating all kinds of havoc in terms of what's an appropriate premium given a new person in interest. For example, what if the person is a former arsonist? And we had the instance of arson in the Minnesota case. What if the person is someone who on their own home insurance had lost coverage because of excessive claims, because of they were a felon, because of fraud, for some unrelated reason? I think you bring those things into play, and that's part of the conundrum. If you were going to do it, I think you would probably have to say, in addition to interested party, you'd have to define a very limited, narrow scope of interest where they could be qualified or characterized as an insured. I don't think that's a good solution for the reasons I just said, but that's one thing you could do. And then say something to the effect of they're considered an additional insured for the very limited purpose of carrying homeowners insurance forward for 30 days, assuming they pay premiums and the like, and that the general liability provisions of the policy or other provisions of the policy or other property wouldn't apply. I think, Representative, if you want to go down that road, which I think does have problems, that would be a way to look at it.
I'm sorry, Mr. Garrity, I don't feel you've really offered us a solution to a problem that exists. So would you do me a favor and for the work session, think about what might be a real solution to a problem that seems to exist?
Certainly, I'd be happy to do that.
Thank you.
I do think, Representative, what the committee has to struggle with is the notion of being an insured as opposed to having an insurable interest. That's what it really comes down to.
Okay, and language for that would be helpful.
Yeah, I think, Mr. Garrity, that what Senator Bailey intended to do was to ensure that if I die and I have deeded my house over to you as a transfer on death deed, and then the house burns down the next day, that you have an insurable interest in the house at that moment, even if you haven't managed to call Mr. Foley and let him know that I died. And he hasn't managed to call the insurance company yet and let them know. And it seems right now that's not the case. You would just be out of luck and the house would be worthless and gone. So that is, in a nutshell, the scenario we are trying to solve. If insured is the wrong word and insurable interest is the right word, then let's use the right word. That's fine. But I do hope that you'll help us with that piece, because it does seem like there's a real problem that's new in Maine that we should solve because of our new probate code. So
I'd be happy to try and do that, Senator. I would point out, and I don't mean to make this more difficult, but this is a convoluted concept in insurance law. But I would point out, if you did have a deed giving the property over to me, and I would automatically have an insurable interest at the time of your death, but I wouldn't be an insured. So I couldn't claim under the policy, and that's what the Fry case teaches us. So I think you have to wrestle with the notion of an insured as opposed to only the notion of an insurable interest.
And an additional interested party. There's all these things we have to wrestle with, and we're asking for your expertise in wrestling with that, because it feels a little bit right now like you're trying to tie us up in language knots in order to have us not change the law so that insurance companies don't have to pay out in this scenario. And we would like that not to be the case, because if it transferred through probate, then folks would be protected. You'd have that automatic protection. So we just want to have a similar parallel protection for folks who get a deed on death.
I understand what you want to do.
Okay, great. Well, I appreciate your help in helping us get the jargon right so that we can get there as a state. Are there any other questions for Mr. Garrity? All right, I don't see any. So next I have to find my list again. Next, we will hear from Charlie Sultan. Good morning, Mr. Sultan. Go ahead.
Morning, Senator Sanborn, Representative Tepler, and members of the committee. It's wonderful to see you. I am Charlie Sultan, attorney here in Augusta, representing the Maine Association of Insurance Companies, which are the Maine-based domestic property and casualty carriers. We are in strong opposition to the bill. Let me sort of get right to some of the questions you had, as well as some additional comments. First, as a lawyer that does dabble in writing wills and so on, I think this is a dangerous mechanism to transfer a home. I think the problem is perhaps because the contingencies that happen in estate planning, creating a death on deed or deed on death transfer is quite problematic for people, and I would hardly recommend it in most cases, perhaps in a few. And I think that's part of the problem, because you do lose an awful lot of protection, both through being able in a will to write contingencies. It is often the case that a beneficiary may die before the grantor of the property. And within a will, you can plan that out so that that deceased beneficiary's interest flows to their children or to the other family members and so on. There's much more specificity and forward planning that happens through a will and estate planning than through these deeds. What happens when that, you actually are going to create probate issues for that deceased beneficiary's heirs when that transfer happens upon the death of, say, the parent in the example we're using. So I'm just not convinced that this is a proper or should be well used or often used planning estate, though it has attractions, especially if you're trying to avoid probate taxes by removing a home from the probated estate. With that said, let me argue why we are against the bill. And that is that you are in fact contravening through this proposal a long-established and current Maine law. Under Title 24A, Section 2406, Maine requires an insurable interest in a property. The reason for that is to prevent fraud. It is very simple. I cannot try to insure an interest I have no insurable interest in, because I can then have a moral hazard by trying to destroy your property that I have gained some kind of insured interest over. You need to have a personal interest in an insurable property as well as a life. And so this is a longstanding principle of not only Maine law, but law throughout the country. And it has been well settled. As Mr. Garrity says, then you have to not only have the insurable interest, you also have to have the privity of contract in order to have the insurance provisions cover you through a policy. It's problematic under the proposal because that insurable interest, you're trying to deem out of whole cloth an insurable interest where there is none by someone who has no interest, pecuniary or otherwise, in that property until a contingency happens in the future, that contingency being the death of the transferor, and so on. So it messes with how we have created protection for the estate. So as we have been talking about, when under almost all insurance, homeowners insurance policies, and we can give you the coverage for what happens on death and send you that HO3 coverage, is that when you die, the interest of the policy, the homeowner's policy, continues and covers the estate of that person. So when the legal personal representative is appointed, that person then is given an interest. And in the interim, before that time, there's an interest that remains with the estate, as well as if there is, using the parent-child example we've been using all morning, if there is a child, whether adult or otherwise, a children or an adult, living as a resident in the household, they remain protected under the policy. Carriers, like the ones I represent, will then continue that coverage generally throughout the life of that estate, or until sometimes to the renewal part where they will transform that named insured into the estate, as Mr. Foley talked about. So there is ongoing protection so that the family doesn't have to immediately run to Mr. Foley for new coverage. Because it operates out of the estate, these new deeds, in essence, by the death, cease that policy of insurance upon the death, because there is no remaining interest that's available for any survivors or the beneficiaries. And as Mr. Garrity talked about, Mr. Foley talked about, there's two parts to an insurance contract, really, in a property, real estate contract. One is we protect your property and so on, and your contents. And the other is that there is liability coverage. In fact, the greater cost to your homeowners is the liability coverage and not the property coverage. And that liability follows you, as was stated, around the world. So by adding someone who has no interest in that household to a policy creates a much larger pool of liability for the carrier. So we'd have no alternative but to add to the cost of the policies for people, which is not, I think, what you want.
Mr. Solden, I'm sorry. Can I just cut you off a little bit, because I think we're getting a little repetitive here. If we change the language to additional interested party, treat them like a mortgagee, and they stand in the shoes with regard to the property and the dwelling and contents coverage, just like a bank would if they had assumed the property, does that solve the issue here?
No, I don't believe so. We'll clarify that for the work session, but I think that is mistaken. Because of the transfer happens, and there is no estate, I don't think that the named parties, the interested parties, have any insurable interest still. We'll send them notices of cancellation or a non-renewal or of renewal, and other kinds of information like that. But I think even on a deed of transfer like that is being used here, if there was a mortgagee listed, I think their interest is extinguished in that property, and their recourse is against the estate, not against the new owner. Unless there is a lien on the property that the, say, for the bank has, they could, use that as a tool for recovery, but not the insurance policy. So I think that's a problem. I'm not sure that it actually works in the manner that was suggested.
Okay, Representative Tepler.
Thanks, Madam Chair. Thanks for being here, Charlie. I continue to be amazed that we have 3 attorneys, we have a real problem, and no one is proffering a solution to the problem. Is the solution to the problem that there is an issue in the new probate code? Or is there just not a solution, so when a house burns down after you've inherited it, but before you've actually taken possession, you're out of luck?
Here's my solution, Representative Tepler. I think the new deed did not take into account obviously the insurance implications of doing what they've done. Unlike a life estate where there is an insurable interest in the remainder, and I could wax poetic about Blackacre and Whiteacre and all that kind of stuff. These deeds do not create, a continuing interest in the estate. The estate has no interest in this property once this person dies. So I don't think they contemplated it, and I don't think there is a solution as is proposed here or in another way. I think the solution and the practical solution is that the probate bar and anyone giving advice to a person creating these deeds has to inform not only the creator of the deed, but the beneficiary under the deed, a notice that they have this issue of insurance. I don't think that by undermining the bedrock of the current insurance principles that not only are in Maine law, but everywhere, is not helpful and not a solution. So I really think it's an educational part on the bar to their clients about the downfall and the risk of these deeds.
I guess I am uncomfortable as a legislator responsible for the content of the law to retain a law that requires the probate bar to interpret for a client, particularly in the case where there may not be an attorney involved. So I'm very uncomfortable with the solution that you suggest, and do feel there needs to be a legislative solution, whether that's eliminating the death deed for the protection of consumers or some other solution that has yet to be suggested.
Representative, I would think it highly unlikely that this kind of deed would ever be executed without the advice of a lawyer, because I don't think they're well known, and so on. And it is absolutely the obligation of an attorney who is advising clients on probate matters and estate planning of all the pitfalls. There's so many different ways, both taxation and transferring a property, real and otherwise, and intellectual rights, to advise them on the pluses and minuses of doing things one way versus another. And that is our job. It's fundamental. And I think this is one aspect that the bar has yet, because these are fairly recent, to fully comprehend all the implications, insurance only being one. I just don't think that the solution is to undermine these insurance bedrock.
Mr. Sultan, couldn't we simply put in language that says that for 30 days you have to treat the beneficiary of a transfer on death deed as if they were the legal representative of the estate?
You could say it. I don't know if it would work because of the contract issues. I mean, maybe. I mean,
well, we regulate the contract. We can force the insurers to put whatever we want into that contract going forward, because insurance is regulated by the state. So I'm talking about a statute that would say, here forward, every contract for homeowners in the state of Maine has this provision in it. We say that if there's a transfer on death deed, then the beneficiary of the transfer on death deeds is the de facto legal representative of the state and has all the same rights and responsibilities as if the home had transferred through an estate.
Well, I mean, you would be putting Maine outside the purview of every state in the union, I believe. You would create a situation where, we've enjoyed, as we talked about for years, in essence, one of the most affordable property casualty markets in the country. And by adding this kind of liability and so on, it threatens that. you could say it will cost everybody, whether you use these deeds or not, because we won't know. And so we will have to charge everybody some factor to cover the cost of an exposure we do not have.
Why is there more exposure in a transfer on death deed than in an estate proceeding?
Because we have little idea of I mean, as I said, it's under the current law for the estate, you do not get liability protection. You only get coverage for the property during that time until it is rewritten for the beneficiary in their name. And so that would be one reason. I think what you would be giving is a larger slice of protection.
Well, I just posited that we change it so that the coverage was exactly the same as if it went through an estate. So I with all due respect, I don't think that's what I just said. I said, what if we treated it exactly like a legal representative in an estate? How does that increase the premiums? I don't understand why that's any additional risk. It just recognizes that we've added this new tool 3 years ago for estate planning, and we want to ensure that Mainers are protected if they use it.
Well, I misunderstood you then. I apologize, but I will take that back to my guys.
Okay.
I mean, you are creating a new liability. I understand you think it's similar, but we'll look at that and analyze it.
Okay, I appreciate if you would do that, because this really is a problem we're trying to solve. And it really feels like there's this sense of like, well, we can't change anything about insurance or property law to match up with the probate code. And that's just not how state law is supposed to work. So I hope we can get some help on this, because I think if we do it ourselves, we may do it wrong. So I'm hopeful that we can get some help in a productive way on this. So thank you, Mr. Sultan. Are there any other questions? All right, seeing none, I will ask if there's anyone else in the meeting who wishes to testify in opposition to the bill. Seeing none, I'm going to bring in Mr. Bernier to testify neither for nor against. Good morning, Mr. Bernier. Go ahead.
Good morning. My name is Dan Bernier. I represent the Maine Insurance Agents Association. I'm also an attorney who practices quite a bit in the area of probate law, writes lots of wills and life estates. I've taught many continuing legal ed seminars on probate law and used to teach it over in the paralegal program at Thomas College. My primary thing that I would just caution you on this bill is the last sentence that says an insurer may not cancel the contract for at least 30 days after the death of the transferor. 15 or 20 years ago, we had an issue that when you would go through probate, and understand these are non-probate assets we're talking about here, I'm concerned about that being extrapolated to the probate situation. 15 or 20 years ago, we had problems that when you die, your will was being probated, some carriers would try to cancel your insurance policy. The Bureau of Insurance weighed in and said, look, if there's a duly appointed personal representative who's looking after and maintaining the property, the risk hasn't changed. You can't cancel the policy. If the property is completely abandoned and nobody's looking after it, the risk has changed. You can cancel the policy. It's a fact-specific question, but as an attorney who practices in this area, I haven't had a problem with it in 15 or 20 years. And it was a great example of how informal discussions here in Maine can solve a problem occasionally. I don't want to go back to 15 or 20 years ago by having that 30-day thing. All of a sudden in probate, we're getting policies canceled after 30 days. The way probate works is you get a personal representative appointed. There's a 4-month period for creditors to come forward. After you pay off your creditors, you can do what's known as a deed of distribution to the devisee, the person who's supposed to get the house or property. Nice thing in probate too is if the devisee doesn't have their insurance policy set up, they can say, well, can you just hold off a week on signing the deed while I get my policy set up? And the personal representative says, sure, we'll just hold up. Let me know when your policy is set up and then we'll just sign the deed. Probate is working really, really well in Maine. So let's not, probate, when you actually go to probate court, this is a non-probate transfer that's revocable. Just let's not mess probate up. The other thing that I would say is, while the parent is alive, I don't see why we couldn't treat this person as the same way we treat a child who holds a power of attorney. A power of attorney does not have an insurable interest in the property, but they have a right to ask questions about the policy, receive notices if it's being canceled. And I do think that was part of the aim of this bill, is that they could be listed in the way you list a power of attorney to receive a notice. If for some reason an elderly parent's not paying their insurance premium, the person who holds this revocable deed would get a notice the policy is about to be canceled. I'll get in trouble if I say what terminology they're using on the policies for a power of attorney, but it's easy to set up a power of attorney to get notice of a cancellation or something. That does not solve the problem of what happens the day the parent dies. And I'm kind of listening to you all looking for a solution on that, and I'm struggling a little bit to come up with what the solution is. I haven't been doing these revocable deeds partially because I want to see them tested for a while before I experiment with them with my clients. I do a lot of wills. I also do a lot of deeds with life estates. And as Mr. Sultan mentioned, with a deed with a life estate, there's an actual insurable interest. In fact, I keep right on my desk the actuarial tables where I can go in and calculate what we call the remainder person's insurable interest if I have to. You also, if they sell it or something, want to be able to calculate that. So with a life estate, this is all nice and clean. There's a percentage based on the life, on how old the life person is, that divides up what your insurable interests are. With that, it's already been a fairly long hearing and I don't want to get too redundant, so I'm happy to answer any questions that anybody would have.
Thank you, Mr. Bernier. I appreciate your comment about not wanting to mess up probate, and we certainly don't want to do that either. What about the last solution that I suggested, which was to deem the beneficiary of a transfer on death deed as a matter of main law to be treated similarly to a personal, is it a personal representative, legal representative of the estate, perhaps for a period of time?
Yeah, I mean, I think part of it is also listening as the first bill of the session, and almost any comments I make on this problem, somebody's going to get mad at me. And I was hoping to get through the first hearing of the session without making somebody mad. But I think there is something that can be done on those lines. My big concern is that if you say 30 days or 7 days, I don't want that applying in probate. And I want you to, like, big black letter, this doesn't apply to a personal representative in probate.
Yeah.
No, I do think there is an underwriting issue that carriers may have to underwrite for that. So the more limited the duration, the less they're taking on an additional risk that they've got to factor. I'd be curious what the Bureau of Insurance thinks. Do they have the data? Is that an underwritable risk if you're doing this for 30 days or 7 days or something? Is there how much? When you look at increased risks, you have to look at, there's ones you have data on so you know how to rate for, and there's ones you don't have data on so you don't know how to rate for. I'd like somebody smarter than me to just say, what you're doing, we have enough data, we'd know how to rate that. Because if they don't know how to rate it, they're going to jack the rates up a lot. If there's really good data, it might only be a slight increase in the policy cost.
Mr. Bernier, can you help me understand, does a legal representative have liability insurance in some way that extends around the world, as we heard from those who came before you, that creates the additional risk? I mean, let me explain my question a little bit better, which is to say, isn't every homeowner's policy already basically underwriting the risk that the owner is going to die and the legal representative is going to stand in their shoes for a period of time?
I tend to think you're right. I'm just not saying I have the hard data on that. And I'm willing to listen to others, but I tend to think you're right that there's not, it provided that, because if you're limiting it, then that person needs to come in and look at the policy. The issue we've always gone through in probate and how we kind of went about that is abandoned properties present a different risk because they're not being maintained. And that's really your concern. If somebody's looking after a property and maintaining it, the risk doesn't really change. And I think 15, 20 years ago, I think Al Ayupa was the superintendent at the time. He's the one that kind of weighed in. The risk, if it's being maintained, the risk didn't change.
Yeah.
And I think we just need to look at it. Do they want to, how is that risk changing if this person is looking after it and maintaining it? And you still might want to give them some leeway if this property is really abandoned, which they can still do. But if you file for probate, that's strong evidence the property is not abandoned. So that's probably more the question that needs to be analyzed. I think there probably is something that can be done. But I'd like to have a few more people than just me weigh in on it.
Understood, and we welcome that as well. And I'm feeling like we should probably move on at this point, Representative Tepler, but go ahead if you want to ask your question.
Just one more question about the issue of abandonment of property, because let's think about that for a minute. If we're limiting the stand and choose for 30 days, 30 days does not constitute an abandonment of property that creates the kind of risk you're talking about, or I certainly hope it doesn't.
I tend to agree with you on that point, but again, I would have others weigh in, and I do think it still could be a fact-specific question. If you've had a relative die recently, you're often cautioned about the amount of information you put in an obituary because criminals read obituaries and engage in identity theft and stuff. So you kind of, you also don't want an obituary quickly say, open house here, nobody's looking after it, go break in. So, someone who does probate and has had a number of relatives die in the last few years, there are certain things you get cautioned on in that situation. And in particular, you will be cautioned by often the funeral home that criminals read obituaries. So I generally agree with you, but I just think, as I said to Senator Sanborn, I think you do want to have a few people more than me just weigh in on that subject.
Okay. Good. I appreciate your input today, Mr. Bernier. And next we will hear from Mr. Yardley. Good morning, Mr. Yardley. Go ahead.
Good morning, Senator Sanborn, Representative Tepler, and members of the committee. I want to clarify that I'm Senior Attorney Ben Yardley. I'm not the U.S. Cavalry coming over the hill to solve all of these questions. I'll do the best I can, though. I have testimony. I think I'm not going to read it. There's been a lot of back and forth already. We'll summarize by saying that we're here neither for nor against the bill. And I'll cut straight to a technical issue. I'm going to skip over the first bullet point. The bill does not put this provision in the Property Insurance Cancellation Control Act, so it technically could apply to commercial property as well. Maybe you don't want to do that. I don't. Just flag that for your
great
food for thought. So we looked at this last summer, and we struggled to come up with a solution in the insurance code, and I think this conversation bears out the difficulty. I will say that I think the goal is to, people are going to do this outside of probate. They're going to do these mechanisms. There's very little that lawyers and insurance companies can do about it. And so perhaps the focus should be on providing some seamless, limited duration coverage for the transferee, with some opportunity for the insurer to take a look at the transferee and underwrite it. It shouldn't need to underwrite the property in most circumstances, although we did cover the problem of property that's not maintained. That problem exists with owners anyway. Maintenance is the phase of construction that begins when the contractor leaves. And another issue is whether the transferee even wants the property. I mean, maybe they don't want to be on it. Maybe they want to convert it to cash and, be rid of it. Senator Sanborn's suggestion, looking back for the precise wording, which I probably won't be able to find in the discussion we've had internally. But I think you are on potentially the right track. We wonder whether a way to do it is to extend coverage for a limited amount of time, treat the transferee as a new insured whom the insurance company gets to underwrite. Liability, if it's correct that let me scratch that. I think the real issue isn't so much liability coverage as it is what happens if the house burns down. And so I'm not sure that's should be such a great concern. And I guess I would point out too that yes, there's an issue with being paid for the extension of coverage. At the front end of policies, insurers issue coverage without being paid. I don't know if that's a regular course of events, but it happens. So there's a risk in the normal course of transacting these policies. I'm sure that, there was a question raised about whether homeowners insurance, homeowners insurers have priced for the risk that a homeowner will die and the property will go to there'll be a PR in control for a few weeks or months. That's probably built deeply into their underlying pricing and might be hard to extract without doing a deep dive into claims they've paid while there's been a PR. I don't know how fruitful that would be to investigate, but I think you can assume that there's been pricing for this already. With that, happy to answer any questions that you want to bring to us.
Thank you, Mr. Yardley. I think with regard to your last point, that was my point, which is to say it's already deeply embedded in the pricing of the policy. And if we were to simply sort of deem this other type of transfer on death to be very similar to the kind we've been familiar with for 10 or 15 years, that it's already priced into the policy and it shouldn't create any additional pricing change. Is that the reasonable assumption that off the top of your head you would think would be the case?
Yeah, don't look too closely at the top of my head, but yes, I think so.
Excellent. Thanks for keeping it light. Are there any other questions for Mr. Yardley? All right. I think this is actually.
Could I close with a question?
Yes.
Do you have things that you specifically want us to come to the table with? I mean, I think we want to be prepared. This has been a pretty far-ranging discussion, and we're happy to be as helpful as we can be.
Thank you, Mr. Yardley. I see Representative Brooks' hand up. Why don't you go ahead?
I had a question, and I'm not sure that it's for the Bureau of Insurance or Mr. Yardley or for Colleen or for Donna. Oh, I'm sorry, for Senator Bailey. but it's one that I'd like a timeline on. I think it was really helpful about saying that creditors have 4 months, and what would be the normal, I don't know if there is such a thing as normal, but kind of the flow of probate, that it seems to give more time for mourning and the insurance responsibilities. So I'd like to have just an overview of like a probate 101 if I could. And that's partially my responsibility. I understand that, but I think that would be just helpful to me, like versus 30 days. And how do we
Okay.
ensure that people don't get these great losses during a time of mourning?
I think Colleen can give us a brief timeline of what would happen if there weren't a transfer on death deed, for sure. Thanks, Representative Brooks. Mr. Yardley, to your question, I think what I'm going to be trying to work with Senator Bailey on between now and the work session, and I am a co-sponsor of this bill as well and have been involved in conversations about it over the summer with the Bureau. But I think this discussion has actually been surprisingly helpful for me in getting much closer to what I think is a solution, because I think the solution is to sort of have us just treat this like a PR situation, like an estate, a transfer by estate situation for some duration of time. So, Mr. Yardley, if it was possible for the Bureau to work with us on some language that might accomplish that type of, I guess I would call it a legal fiction, right? That for a period of time, the insurer has to operate under the legal fiction that this transfer on deed death was actually operating more like the appointment of a PR in an estate, with all of the protections and responsibilities, for example, maintaining the property that would entail. So I guess our request would be for help with language.
I'll see what we can do. I'm wondering if our approach is going to be more on how long the transferee is in there and how long the insurer has a chance to figure out who it is.
I think we're saying the same thing. I do think the duration is part of the issue. But yeah, great. Okay. We'll continue to work on this, and we appreciate your input. I certainly did not expect this was going to be an hour and a half long hearing today. So thank you for everyone's patience. Are there any further questions for Mr. Yardley or requests for the work session, or folks in the meeting who wished to testify that I have not yet called on? All right, seeing none, I'm going to close the hearing on this bill. I don't have the LD number in front of me, and on LD 1752, and I'm going to suggest that we take a 5-minute break and reconvene at 11:33 or so to have the last two hearings of the morning, which I really think will be much shorter and less back and forth. So, all right, with that, 11:33, we'll see you back. It is 11:34. If folks are at their desks, if they could turn their video on and let us know that they're with us. Great. And then I will turn the gavel over. Well, we need a couple more faces. We've got 5. There's one more. We'll give it one more minute, and then I will turn things over to Representative Tepler to get started.
Mark and Josh, can you show us that you're here if you are, please?
Great.
Thanks.
Oh, Representative Quint has her hand up. Go ahead.
Just to let you know, every now and then you freeze. So when you see my video turn off, it's just so that I can still pay attention to what's going on. I'm still here, even if you can't.
Wonderful. And thank you for that. I think we've all experienced that from time to time. I know even in Southern Maine, Senator Brenner had a little internet glitch this morning too. So it can happen anywhere in the state. So appreciate you being here, Representative Quint. Go ahead, Representative Tepler.
Thank you. I just was going to say thanks to Representative Quinn for letting us know. And I see that Representatives Brooks and Matheson are back with us. So I think we should probably get started because now everyone who is on the screen is in attendance. So welcome back to the Committee on Health Coverage, Insurance and Financial Services. We're proceeding with our public hearings this morning. And next up is LD 1815, an act to revise certain financial regulatory provisions of the Maine Insurance Code to be consistent with model laws from the National Association of Insurance Commissioners. And this is presented by our own Senator Sanborn. So Senator Sanborn, please introduce the bill.
Thank you, Representative Tepler and members of the committee. This bill, LD 1815, and I won't read the whole title, was proposed by the Department of Professional Regulation and specifically the Bureau of Insurance. The primary purpose of the bill is to keep pace with evolving standards for financial regulation by adopting the latest updates to the National Association of Insurance Commissioners Model Holding Company Act. These amendments require insurance groups to file a group capital calculation, require liquidity stress testing for large life insurers, and provide safeguards when insurers outsource essential services to affiliates. The bill also proposes a variety of other technical updates and corrections to the financial provisions of the insurance code. I believe Mr. Yardley is here to explain in more detail, and you absolutely will wish to defer questions until then, but I would be unhappy if you ask them to me. I'm changing their testimony for me on the fly because this is very technical stuff in a department bill. So I will defer to Mr. Yardley at this point. Thanks. You're on mute, Representative.
Thank you. Thank you very much, Senator Sanborn, and we will welcome Mr. Yardley to testify in favor of the Bureau's bill. Can somebody bring Mr. Yardley over, please?
He's on his way.
Thank you. Welcome, Mr. Yardley.
Thank you, Representative Tepler, and thank you, Senator Sanborn, for sponsoring this bill. We appreciate that very much. And members of the committee, I am Senior Attorney Ben Yardley. I'm here to testify in support of LD 1815. As Senator Sanborn explained, the bill makes 3 substantive changes to the Maine Insurance Holding Company Act. First, the group capital calculation provides a metric for evaluating the overall financial position of an insurance group as opposed to its members individually. A calculation at the group level corrects for inaccuracies that can arise from looking at related legal entities one at a time in isolation, which can lead to inconsistent treatment of transactions between those affiliates. Second, the liquidity stress test for large life insurers is a key element of the NAIC macroprudential initiative. And third, the bill includes new safeguards to ensure the continuity of financially impaired or insolvent insurers' essential services when a non-insurer affiliate handles them. And these address the problems that can arise when the insurer is taken into receivership, while the service provider is outside the scope of the receivership laws because it is not an insurer and it is a separate legal entity. The bill also makes some technical changes to harmonize information sharing provisions and the use of certain terminology throughout the Maine Insurance Code. Most urgently, adoption of the group capital calculation is necessary because Maine is the lead state for the Unum Group, which has operations in the United Kingdom and the European Union. If we do not have the NAIC group capital calculation in place by this year, the covered agreements with the federal government will allow the UK and the EU to impose their own capital standards on the entire Unum Group as a condition to being there, doing business there. So the UK and the EU capital standards are consistent with US standards, and together this introduces, they are inconsistent with US standards and introduce instability in long tail lines of business, such as annuities. These products have disappeared in the EU, and imposing EU standards on US groups, such as Unum, if this bill does not become law, could be disastrous for any company that becomes subject to the EU standards. In addition, the group capital and liquidity stress test amendments will be necessary to maintain the Bureau's accreditation with the NAIC as an insurance regulator. Accreditation, among other benefits, allows other state regulators to rely on the Bureau's examination of Maine domestic insurers. This saves unnecessary examination costs that other states would impose on insurers here. The outsourcing amendments have not yet been adopted as accreditation requirements, but they are likely to be under consideration in the near future. And the NAIC's accreditation committee has issued a statement strongly encouraging states that are revising their holding company acts also to include the outsourcing provisions, which is why we have included them. So thank you. I would be glad to try to answer any questions now or at the work session. I would point out, despite Senator Sanborn's comments about me, that I have a wingman. And if I cannot answer your technical questions, he will certainly be able to, since he's been involved in these discussions significantly.
Thank you so much for your testimony, Mr. Yardley. Are there questions from the committee for Mr. Yardley? Seeing none, we appreciate your testimony. We have two other folks wishing to testify in favor of the bill. First up, we'll have Mr. Garrity. Welcome back, Mr. Garrity. Please go ahead.
Thank you, Representative. Senator Sanborn, Representative Tepler, and members of the committee, I'm again testifying on behalf of APCIA. Let me say at the outset that we strongly support the legislation. We recognize the necessity of dealing with these issues, and we certainly support the model, and we were involved at the NAIC in the creation of the model. We do have two proposed changes. I've discussed them with the Bureau, and I'll let the Bureau relate its comments on them. Both of the proposed changes that we would like to see the committee consider are from the Model Act. So they've been removed from the Model Act in this legislation. The first one deals with the issue of whether some of this data can be used to, in some fashion, rank insurers or insurance holding companies. We don't think that's the point of it, and I think that's why that language was put in the model. And the second point is that while we already say that holding company information is confidential, not a public record, not subject to subpoena, and has other standards, it doesn't say that it's proprietary and trade secret. Those are two of the terms that are in the model. So we would urge the committee to consider these changes, and I would be happy to try and answer any questions the committee might have, Representative.
Thank you, Mr. Garrity. Does any member of the committee other than myself have a question? No. Seeing none, I will ask you a quick one, Mr. Garrity. What reason did the Bureau of Insurance give for not including these aspects of the model bill in the legislation?
With respect to the first point, the language that was in the model, which we had put in our draft and which we discussed with the Bureau, basically said, words to the effect of, it's not intended to be something that ranks insurers or insurance, and the revisor's office raised concerns about that as to whether it was a substantive change to the law or simply a reference that didn't need to be there. We talked about that with the Bureau, and we proposed to change the language to rank insurers or insurance holding company system generally. Mr. Yardley and I talked about that as recently as yesterday. The Bureau has not agreed to these changes. Neither have they evidenced strong concerns with them, and we're continuing to talk to them about them. The second point, I think the Bureau's position is that when the words confidential, not a public record, not subject to subpoena are used, that is as broader a protection as including something as proprietary or trade secret. First, we see no harm, given that it's in the model, of adding those terms, especially if confidential is interpreted to be as broader. Second, we are concerned that there could be instances in litigation where somebody says, we don't care if you consider it a trade secret. We think it should be produced, and we think it otherwise could fall outside of the scope of confidentiality under a FOIA request. And I think those were some of the things considered at the NAIC. Now, I believe Mr. Wake from the Bureau was actively involved, and I'm sure he could shed more light on this issue as well.
Thank you, Mr. Garrity. Any other questions from the committee?
Thank you.
Seeing none, I will next call back Mr. Sultan testifying in favor of the bill.
Thank you, Representative Tepler, Senator Sanborn, members of the committee. I'm Charlie Sultan. I represent the Maine Association of Insurance Companies. This bill is a perfect example of the longer the bill, the easier it is to get through the process, I think. It's the one-pagers we have to worry about. We are in support of the bill for all the reasons that both Mr. Yardley and Mr. Garrity have stated, and we are in support of the suggested amendments that Mr. Garrity is proposing on behalf of his client. And with that, I will wrap it up.
Thank you, Mr. Sultan, and I'm looking to see if anyone from the committee has a question for you. Seeing none, that is actually the end of the list of those registered to testify that I have. Is there anyone among the attendees who would like to testify on this bill? Seeing none, I will close the hearing on LD 1815 and move on to our next hearing on LD 1836, which is also presented by our own Senator Sanborn. So please take it away, Senator Sanborn.
Thank you, Representative Tepler. And again, this might be a circumstance where the name of the bill is longer than the hearing. I am here to present LD 1836. The bill was developed by the Bureau of Financial Institutions, would amend the Maine Banking Code Title 9B by clarifying Maine's financial institution merger statutes and modernizing other sections of the code. I get to introduce all the fun bills. The provisions include clarifying language that notice in a meeting about merger plans need not be held when investors provide unanimous consent to the activity. The bill also clarifies that when a Maine financial institution merges or consolidates into an out-of-state financial institution, then the Maine financial institution's charter terminates automatically upon merger. And the bill includes technical amendments that update the U.S. Treasury rate used for calculating the interest paid on a mortgage escrow accounts and make an inflationary adjustment to the minimum capital requirement for new Maine financial institutions. A representative from the Bureau is present to provide further testimony, and he will answer any questions that you may have about the bill. Thank you.
Thank you very much, Senator Sanborn. And with that, I will turn to Mr. Lorendo of the Bureau of Financial Institutions speaking in favor of the bill. Welcome, Mr. Lorendo.
Good morning. Can everyone hear me?
Yes, it would probably be helpful if you turned up your volume slightly.
Is that better?
Yes, thank you.
Senator Sanborn, Representative Tepler, members of the committee, my name is Gordon Lorendo, and I'm the attorney for the Maine Bureau of Financial Institutions. On behalf of the Bureau, I'm here to testify in favor of the Bureau's proposal, known as LD 1836, an act to amend Maine's financial institution merger statutes and modernize certain sections of Title 9B. The bill touches on a variety of different sections and generally seeks to streamline, clarify, and modernize existing banking laws. It is the Bureau's understanding that the Maine Bankers Association and the Maine Credit Union League indicate no objection to the proposal. Section 1 of the bill clarifies that, should the need arise, the superintendent may employ experts and professionals from other banking agencies or from the private sector to assist the Bureau in carrying out its mission. The ability to turn to experts, such as retired bank examiners from other states, ensures that the Bureau can meet its responsibilities in an increasingly complex financial sector. Sections 2 and 3 of the bill raise the minimum capital required to establish a financial institution from $100,000 to $500,000. The amount has not been changed since 1975, and the new number reflects an inflationary adjustment. Sections 4 and 9 of the bill clarify that a financial institution's main charter will terminate automatically if it merges or combines with another institution and the other institution is the surviving entity. Termination happens upon merger because the merging entity no longer exists after a merger as a separate business entity. Section 5, 7, and 8 of the bill clarify that an institution need not provide notice and have a meeting of investors or decision makers when those investors and decision makers are able to provide unanimous consent for a proposed corporate activity. Section 6 simplifies and clarifies the process for certifying approval of a merger or consolidation plan. The proposal allows the president and vice president of a bank to certify the adopted plan and to provide evidence of approval by investors and mutual voters. Section 10 of the bill replaces the U.S. Treasury target rate used for calculation of interest paid to consumers on money held in mortgage escrow accounts with a substantially equivalent rate. The rate currently cited in statute has not been published in many years, and financial institutions have had to substitute a comparable instrument. Thank you for the opportunity to testify before you today. I'm happy to answer any questions from the committee.
Thank you, Mr. Lorendo. Any questions on the committee for Mr. Lorendo that he can take to the Bureau of Financial Institutions? Okay, seeing no questions, and this is a pretty technical bill. Is there anyone in our attendee panel who would like to testify on this bill? Seeing no hands, no little electronic hands go up, I believe that that concludes testimony on LD 1836. An act to amend Maine's financial institution merger statutes and modernize certain sections of Title 9B. And actually, we have reached the end of our work for today. I have one brief announcement for the committee, and then I'll turn and see if either Senator Sanborn or Ms. McCarthy-Reed have any announcements or things they want to go through. My announcement to the committee is to recognize that our next hearing on Tuesday, January 18th will begin at 11 a.m., not at our usual time of 10 a.m. And also, although it's not yet up on the website, there will be a 12:30 confirmation hearing for one of the candidates for the advisory board for the Office of Affordable Health Care. Because that person was unable to make the 1 o'clock set of confirmation hearings. So we will have an 11 o'clock briefing and a 12:30 confirmation hearing, and then again, a series of confirmation hearings at 1 p.m. for next Tuesday. So Senator Sanborn, do you have anything you'd like to add?
No, I don't think so. Everyone should have a wonderful weekend, and we'll have a long day, I think, on Tuesday. So enjoy your long weekend.
Yes. And Ms. McCarthy-Reed, is there anything that we should know?
No, I think you covered the committee schedule. It would be good to touch base with the two chairs either now or this afternoon to talk about a work session schedule for next week if you'd like. I don't think it will take long, but we haven't put out a schedule yet of work sessions.
Yep, Colleen, why don't you send us a Zoom link and we can jump on to that.
Right back on.
Great.
Yep,
I don't know that the entire committee has met our new clerk, Edna Caford, yet.
Hi.
So she is actually present by face, whereas she usually has a seal over herself.
I do.
Great.
I am very new, so please be patient with me.
Oh, I think this committee is pretty kind as far as things like that goes, Edna.
I
So
do
thank
too.
you for that. So with that, I guess that brings our work to an end, and I wish everyone, along with Senator Sanborn, a really good weekend. And we will see you on Tuesday at 11.
Bye. Thank you.
We'll come out of the clock. We're meeting.